Thank you, Your Honor. And please report, I'm Shea, Moxon, attorney at Humphreys, and I represent Elsa Chacon as personal representative of the estate of Romeo Chacon. This is an Engle progeny case, and we have raised two issues regarding the requirements for membership of the Engle class, particularly the first part of the class definition that refers to all Florida citizens and residents. And I'd like to spend most of my time on the first issue. Either one of these issues would be an independent basis for reversal, but I'd like to focus on the first issue, if I may, which is whether this class definition requires someone to be both a Florida citizen and a Florida resident at the relevant time to be qualified for class membership, which is what the trial court instructed the jury, or, as we maintain, is either one sufficient so that a smoker could be a Florida citizen or a Florida resident and qualify for membership in the class.
This specific issue hasn't been addressed before, has it?
It has not been...
The specific issue, I know there's a bunch of cases going around it. But is
yes,
there...
it has not been framed as an issue.
Right.
In the Engle case, where the court said, we're going to answer this question and here's our answer.
What's your best case for your position?
Well, our best case is, I believe, Damianakis, and I realize that this court, there's a conflict between Damianakis and this court on our second issue. And on the first issue, the court has explicitly said that it is citizenship or residency. The court wrote, we conclude that as long as an individual was a citizen or resident of Florida as of the cutoff date, and his or her smoking illness manifested, and then it goes into the timing issue, which goes to the second issue. But they say citizen or resident there. That's on pages 467 to 68 of the opinion. And there's a very similar statement on 462, spelling out the only requirements for membership in the Engle class are, and then cutting ahead a little. Number 2, he or she was a resident or citizen of Florida on or before the cutoff date. That's page 462 of the opinion. Mm-hmm. And then also in the 5th District's opinion in Bishop, the same thing. In that case, their ruling on the second issue is consistent with this court's decision. But when they were referring to this part, the first issue, they say inclusion in the Engle class requires Florida residence or citizenship when the disease or condition first manifests itself, not at the time of death. And in this case, in Bishop, that actually was an issue that our firm argued in our briefs. That was something that we pointed that out. The pages, we've asked the court to take judicial notice of those briefs. Pages 21 to 22 of the Bishop initial brief and 4 to 6 of the Bishop reply brief. So this was an issue we argued in that case, and although the court did not say this is something that we want to address, it shows up in the opinion. So when these courts have looked at that part of the definition and basically interpreted it and said what it means, as far as what does this require of an individual smoker, when you're switching from the view of the class definition of a whole to what needs to be proven by a specific plaintiff, they both said Florida citizenship or residency. And we submit that this follows simply from a plain reading of the class definition. I know both parties have referred to it as a grammatical issue, but it's really a matter of plain reading. We have a group.
Do we apply the same principles that we would apply to statutory construction, which is what a lot of both sides argue in this case, to what essentially is precedent, the rewriting of the class definition in our Engle decision from 1996?
I believe so, Your Honor, because
do courts write with that level of metaphysical certainty that legislatures or rulemaking bodies draft for?
Not always, but there are instances when you can tell that some phrase was set out to govern future proceedings and that future courts are going to have to construe this language. And in any of those situations, these canons for statutory construction or interpretation of contracts. They're good tools. They're really good tools for analyzing any kind of writing that needs to be analyzed in a logical and critical manner. So, Your Honor, you're correct. There are times when language used in a case isn't that precise, but this is the Engle class definition.
I ask because I do this for a living, and I'd like to think I write clearly, but I know that I don't always. And I know that because then I look back a while later and I see, wow, I wish I had written that differently. Kind of like the last case we just had, where we're thinking 7 years later what one sentence in a case means as applied to remand proceedings. And I just wonder that in parsing through some of this language, do we give it this sort of reading that we would give a statute? Or is this one of those things that a court in its discretion can take a look at and say, this is what I believe it means to the best of my ability, and we give wide discretion in jury instructions to allow a court to craft something that is consistent with what appears on the page? Is this more like the latter, or should we treat it more like the former?
More like the former, but even before you get to the canons of interpretation or construction, always the first step is plain meaning.
Well, plain is, there's an and in there, and the court put an and in the instruction. You're telling us that not only is that decision error, but it's error such that no judge in their reasonable mind could have reached that decision. That's what an abuse of discretion means. And I have to tell you, I can only speak for myself, but that's a hard thing to be able to say, that there is no reasonable decision a judge can make, that is a valid use of the court's discretion.
Well, Your Honor, on the standard of review, if I could respectfully submit that, in this instance, both parties have agreed that this is an issue to be reviewed de novo, because it's a question of law. It's a question of what needs to be proven to satisfy this definition. So, however the court phrased the instructions is one thing, but as far as the substance of what it conveys, what is required, that is a question.
Let me ask you this. If the court had put in the instruction, had read, you qualify, a plaintiff qualifies as a class member if, and then put all citizens and residents, just quoted directly from the 1996 opinion, and left it at that, would that have been an abuse of discretion?
Yes, because it'd be a very confusing instruction.
So putting I just want to be clear, so putting exactly word for word the language in our opinion would be an abuse of discretion?
Yes, because the first part of it would start with a singular person. A plaintiff qualifies for the class membership if, and then the rest of the language would be phrased in terms of plural. Plural persons, citizens and residents.
If plaintiff is one of the following class, colon.
And if plaintiff is one of the following, yes, then
that would be fine, even though it's and.
Yes, but it would be clear to say that a plaintiff qualifies for class membership if he is a Florida citizen or Florida resident.
No, it wouldn't say or. It would say all Florida citizens and residents. And they could get up, the tobacco company could get up in front of the jury and say, that means it needs to be both. You could get up and say, no, it's really an or, not really an and we leave it up to the jury. And we wouldn't be here. That wouldn't be an abuse of discretion. You would agree with me?
Well, since you explained it that way, actually, I do believe it would be an abuse of discretion because it would be a confusing, ambiguous instruction that could be interpreted either way. And this is something that needs to be explained clearly to the jury.
See why this is hard?
I appreciate it, Your Honor, but our position is that this first phrase defines a group that contains different types of people. So each type of person can be a member of the group. It's all Florida citizens and residents and their survivors. So everyone who's a Florida citizen, everyone who's a Florida resident, and everyone who is a survivor of either one can belong to this group. And of course, tobacco would never, the tobacco company, Philip Morris, they would never claim that somebody needs to be both a Florida citizen and a Florida resident and a survivor of both to qualify for class membership. But yet, all three words are going by and. So our point is that this is actually how the word "and" works when it is used this way. And if it helps make it any clearer, to hear this used in a full sentence, the class notice that was published in the newspapers, this stated it as a full sentence. The class action lawsuit is being brought on behalf of all Florida citizens and residents and their survivors who have suffered, presently suffer, etc. So our position is any person, ordinary person reading that notice, that any reasonable interpretation is that this class action is brought on behalf of each Florida citizen who meets the other requirements, each Florida resident who meets those requirements, and any survivor of either one. You know, I've given examples in our briefs of a veterinarian who treats cats and dogs. I referred to a class of butchers, bakers, and candlestick makers, but while I was getting ready, I thought of a more real-world example, something that really exists, a plumbers and pipe fitters union. There are such things, plumbers and pipe fitters unions. So a plumber can be in the union, a pipe fitter can be in the union. If somebody is both a plumber and a pipe fitter, they can be in that union too, but they wouldn't have to be both. And so our position is that this is the plain, natural way to interpret this class definition. And if the court has any questions about harmful error or Philip Morris's two-issue rule, I mean, we...
What about the two-issue rule?
Well, the two-issue rule does not apply mainly for two reasons. First, in the defense context, it only applies to alternate affirmative defenses, not elements. To merely deny two elements of something that the plaintiff has to prove does not constitute two defenses that can trigger the two-issue rule. And that's all Philip Morris says they did here. They're denying two elements of class membership. The trial court phrased citizenship and residency as elements. Philip Morris says we deny both of them. Well, under Greenwich, that does not trigger the two-issue rule, merely denying two elements. It'd be like denying negligence and causation in a negligence action. That doesn't trigger it. It looks for two defenses, like failure of condition precedent, statute of limitations. Those are defenses. And I could explain more. I don't know.
No, that's fine.
Okay. And the other point is that in its argument to the jury, Philip Morris conceded Florida residency. And what the two-issue rule looks at is what defenses are argued to the jury. And then closing argument, defense counsel said, residence can be in two states, and the evidence is he was in two states. But residence really isn't an issue. The issue is citizenship. Because citizenship, which the plaintiff has to prove, you can only have one. That's on pages 32, 27 to 28 of the trial transcript. So to recap, two-issue rule only applies to actual defenses, not merely denying elements. And second, they didn't even deny the element of residence in their argument to the jury. And it's the argument to the jury that the two-issue rule looks at. And I can expound on that any more if necessary, if the court has any other questions. Briefly on our second issue, we realize that this court is bound by Rearick, which held that the citizenship or residency element has to be met at the time of diagnosis or manifestation. We submit that that's not supported by the Supreme Court's Engle 3 decision or the class definition. So it'd be up to this panel to either recommend to the full court to reconsider that en banc or to follow Rearick and affirm and certify conflict with Downey Methods. Because that's a separate, independent issue. Either one of these issues are sufficient grounds for reversal. And I could either address the cross appeal now if you like, or say
Go ahead and address it now.
Address it now. Well, Philip Morris is arguing for this legal residency standard as a definition of residence, and that's not the correct standard because legal residence is, for all practical purposes, the same thing as citizenship. Citizenship of a state is determined by where somebody is domiciled. at least with respect to United States citizens. And Mr. Chacon was a United States citizen. So for every United States citizen, your state of citizenship is determined by where you're domiciled. Legal residence means the same thing as domicile. All the jury instructions that they submitted defining legal residence were standards for domicile. So your argument would basically make residence mean the same thing as citizenship, but that cannot be what was intended in this definition. And there are cases that are legion that explain that residency is not equivalent to domicile. Residence doesn't mean the same thing as domicile or legal residence. Resident is anywhere where somebody, resident is anyone who lives in a dwelling place with no present, meaning immediate intention of removing themselves therefrom. A residence is any dwelling place, however, whether permanent or temporary. You can have more than one residence, but a legal residence or domicile, there can only be one of those. That's a person's permanent home. So that's where they always intend to return, even if they live somewhere else. So everybody can have multiple residences throughout the country, but only one domicile. And Philip Morris, the point of their cross appeal is to try to collapse everything so that it all means the same thing as citizenship with this legal residence standard. This legal residence means the same thing as domicile. And in fact, at the charge conference, defense counsel conceded that the reason why Philip Morris had not submitted any jury instructions defining citizenship was because they submitted these legal residence standards instead. They were arguing for that standard instead of citizenship. So if there are any questions on that issue, I could address them, or
We'll let you reserve some time for rebuttal.
okay. Thank you.
Take me way over. Thank you very much.
Morning, may it please the court. Jeffrey Michael on behalf of Philip Morris, USA. I'd like to start with the proposition that if you take plaintiffs' positions together on the main appeal and the cross appeal, their position is that someone can be a member of the Florida-only Anglo class after this court reduced it to Florida only, despite being exclusively a citizen and exclusively a legal resident of another state like New York.
Let me walk you through the precedent. Let's start there. Okay. This is from the Supreme Court's Engel decision in 2006, and I want to focus explicitly on the conclusion section where it goes over everything. And on page 1277, the Supreme Court said, the class consists of all Florida residents fitting the class description as of the trial court's order dated November 21st, 1996. You agree with that? The case says that.
And I agree that that is a quote from the case.
Okay. There it's focusing on residents, correct?
It is, and
Okay.
there's...
To the exclusion of citizenship.
Right, it's certainly not addressing that issue, and otherwise, in the opinion...
Well, I don't disagree that it doesn't address the issue, but we have been admonished, as of others, for straying from the very explicit language that the Supreme Court has set out in its Engel decision. And there the court was clear about describing what the class was, and there it said all Florida residents.
Right, well, there's two potential reasons for that. The first is that they're just using short phrasing for what they had said earlier, and they do quote the...
So they didn't really mean it, is what you're saying.
They didn't mean it to be read literally.
Okay.
Correct, that's one possibility.
So they wrote it in the conclusion section, but didn't want us to read it literally?
Well, it's, as Your Honor was saying, courts, especially in a long opinion like that, where you previously said citizenship and residency numerous times, you get to the end and you use shorthand.
In the part where they say this is what we hold?
And so there's another possibility,
Okay.
which is that when they were conceptualizing of residency, they were conceptualizing as legal residency. So they were, as plaintiff is arguing should not be done here, collapsing the citizenship into residency.
Okay, let's put that aside. Let's talk about our Rearick decision, one that you rely on yourself. This is from 2011. This is what we said Engel is described as, quote, and this is from page 9 to 45 of the decision. The qualification for membership in the Engel class requires plaintiff to show that the decedent was, I say decedent, I'm sure there's other people who say it otherwise, so I apologize, decedent was a resident of the state of Florida at the time of the medical diagnosis of a smoking-related disease, so forth and so on.
Right. And again, you've got the same two possibilities.
But that there's describing what angle is.
Well, but this issue, as you know, I think was conceded by both sides, this is an issue of first impression. No court has said
I'm not saying that it's a holding of the case that we are bound by. I would
Right.
agree with that. But what I am saying is, you have Engel describing what the class is. You then have us in Rearick describing what the class is. And then Bishop, a case you also rely on, from 2012, describing Engel 3 as follows. This is from page 467 of that opinion. In Engel 3, the Supreme Court held that the Engel class included Florida residents who have suffered presently or suffer, who have suffered, presently suffer, or who have died from diseases and medical conditions caused by their addiction to cigarettes, so on and so forth. There, again, it uses the term residents.
Right, so you either have courts using shorthand, or you have them not
How does that shorthand when
concentrating.
it's a description of the holding of the case on point?
Well, because it's not an issue, so you're not concentrating, the court's not concentrating on getting that precise aspect of its language.
All right, then you have the second DCA in Domanicus, who, I won't read it, but also specifically described it as an or, not an and.
Right, they did, again.
So so you have Engel itself, and every DCA that I have seen, that we've just gone over, has described it as either Florida residents or an or, correct?
Well, incorrect, because those same decisions, and we put the pages, use the and throughout.
Well, they go back and forth in the same opinion.
Exactly.
They use and, but they also use or.
Right.
So it wouldn't infer, based on your arguments, wouldn't it infer that all the courts look at the and as being an or? When you look at where it comes from, which is all Florida citizens and residents. When it first started, it was all United States citizens and residents. It got pared down basically by the third DCA.
Correct.
To all Florida citizens. So it appears that every court, Rearick, Bishop, the one out of the second, I can never pronounce his name, Demoniakis, all of them seem to feel that what it means is all Florida and all Florida citizens and all Florida residents.
I don't think that that's what the courts are doing. They're not concentrating on that.
Well, how can every one of these districts, I understand your argument, but let me be a devil's advocate with you. How can every one of the districts be using shorthand?
Well, again, the issue has not been before them. But there's a possibility they're not using shorthand when they just say residents and omit citizenship, and that possibility is that they're doing what the Walker v. Harris case says, which is when you read residents in a legal treating, when you read it in a statute, when you read it in an action, you read it as legal residents.
Well, then how do you equate every one of the cases using or? They specifically in talk, now granted it's indictive stuff, but every one of them says citizenship or residence.
Well, I think that's in Bishop, I'm not sure. It's not in this court's Rearick opinion. So to the extent that, it will be dicta from outside of the district, I don't think it gets you very far. You need to, this court's precedent is the original Engel interlocutory appeal and Rearick. And you need to think about what this court was doing in the original Engel interlocutory appeal. It was saying Florida is going to have its own class. If New York wants to have its own class, New York can do so. Under plaintiff's reading, a person, Mr. Chacon, would have been in both a Florida class and a New York class had a New York class existed. And in order to prevent that from happening, to really give force to this court saying we're going to have a Florida-only class action, you either have to do what was done by the trial court here, which is make the ands read as an and normally reads, and make it citizenship and residency, or you have to do what we suggest in the cross appeal, which is to make residency mean legal residency.
Well, I understand in Rearick that in the holding it's talking and it says residency. But was there a question in Rearick whether or not she was even a citizen?
Well, it depends on what you mean by citizen. In terms of a U.S. citizen, that's certainly.
No. Citizen of the state of Florida.
No.
You know what I'm talking about, citizen of the state of Florida.
Well, I mean, these issues merge together. No, there wasn't an issue of.
The only
whether or not-
issue was the cutoff date and whether she had been a resident of Florida.
Correct.
There was no issue as to citizenship.
Right, well,
So
'cause-
the court specifically, Uric just uses residency. Am I correct?
it does, yes.
Because there wasn't an issue of citizenship.
Well, there wasn't an issue of
Am I correct on
citizenship.
that?
It
Am I
depends.
correct on that?
It
Am I
depends
correct
on
on
what
that?
you mean by
No,
residency.
counsel, the word
The
citizen.
word citizenship is not in RERIC, and I don't think it was briefed separately. Our position in RERIC was, though, that residency means legal residency.
Mhm. I was also on this panel. It seems like today's my lucky draw on all of these cases.
So if you're reading residency to mean legal residency, as we think it should be,
Right,
and plaintiff were correct that that makes it superfluous with citizenship,
gotcha.
then to that extent, citizenship could have been at
Gotcha.
issue there. But no, in terms of was it, separately briefed. Now, we disagree that residency and legal residency and citizenship are necessarily superfluous, but there certainly is a large amount of overlap between the concepts.
If we were to agree with you, then will we have to cite a conflict with the second and the fifth?
I don't think, not on that issue,
Right.
because it's certainly not a holding of the second or
Right.
fifth.
But it's certainly something that's apparently either has been or is going to cause great confusion somewhere along the way.
Well, as you can see, we're now almost 10 years into the Engel litigation, and this is the first time that this has made its way onto an appeal. So I wouldn't say it's necessarily something that's causing havoc in the trial courts.
Do you agree that the term "all" modifies both citizen and Florida citizen and Florida resident?
I think that's correct. I'm parsing over the term "all." I'm not sure it's really a necessary term.
It's there.
It is there.
Do you believe that it modifies do you believe that it modifies Florida citizen and Florida resident?
I think, yes, it modifies the entire definition.
So you agree it should be read all Florida citizens and all Florida residents?
No, I wouldn't break it down at all.
Why?
You keep Florida citizens and residents as a singular group, and then it's all members of that.
Why is that? What grammatically supports that reading?
I think the word "and" is typically read to be conjunctive, and that's a Florida neurological birth
A
complication.
few years ago, Justice Scalia wrote a book called Reading Law with Brian Gardner and addressed this very issue with regard to each and every, but it could easily be applied to all because it's the same sort of word. And I'll read it to you. It says, with the conjunctive "and," proper usage would assign the adjective every and each to both of the following nouns, so that every husband and every father means every husband and every father. I'm sorry, every husband and father means every husband and every father. But it is easy to mistake the meaning for every husband, dash and dash father. Easy enough, in fact, that the conjunctive uses here illustrated might be considered ambiguous. If the husband dash and father dash meaning is intended, the sentence should be recast that way, or perhaps as every husband who is a father. In the disjunctive instances, of course, it doesn't really matter because there wouldn't be an ambiguity. And then it contrasts that where there's an indefinite article used, the "a." So if it was a citizen and resident. There, the book reads, with the conjunctive wording, only someone who fits both descriptions must comply. With the disjunctive wording, someone who fits either description must comply. Why is that not a fair grammatical reading if I'm parsing it out like I would a statute or a rule or a regulation?
Right. Well, first, we do say in our brief that statutory construction principles aren't necessarily what applies here. Courts, we quote a case where courts use cease and desist, arbitrary and capricious. The courts use redundancies and different grammar than statutes that go through committees and parse the wording. But in terms of, is that a fair summary of how this construction can work? I think it is. Both sides always argue that they're correct on the plain language without any construction, et cetera. But to the extent that it is ambiguous and it can be read two ways, and typically struggling with the interpretation is assigned that it can be read two ways, then you need to look at the purpose of the definition. And the purpose was to make a Florida-only class. The purpose was to say every state can have its own class if every state wanted to. We're not going to be adjudicating nationwide other states' injured smokers within the Engle class. And so you start with the initial class definition, bring it down to Florida, and what the trial court did here, giving and its conjunctive use, is it made sure that people who were in the class were going to be people who were bona fide citizens of Florida. The alternative way to get there is to ensure that they're legal residents. If I have a minute, I'd like to discuss the two issues.
Sure.
The problem you have there is the plaintiff is the one arguing that they should have had two different avenues to prove class membership, citizenship, or residency. But we don't know, based on the general verdict form, whether or not the jury here would have adopted either of those theories. So, and the reason that we don't know, the reason there was a general verdict form is because it was by agreement of the parties and the court. There was no objection made below, and that's the two-issue rule waiver. Now, plaintiff says we conceded residency below, but that's not what happened. There was a motion for a directed verdict that happened after the charge conference and before closing arguments by plaintiff on residency, on the temporary residency standard that the trial court used. And we argued against it, and we won that motion. So we took the position that there was a tribal issue of fact on residency, and the trial court agreed. And then during closing arguments, certainly citizenship was a higher hurdle for plaintiff to meet. So our counsel focused the jury on citizenship. But what the counsel is saying is, I'm going to discuss citizenship because there's evidence on both sides of residency, whereas I think citizenship is much stronger for us. So it wasn't a concession of residency. There's been no appeal of the denial of the UD. So that acts as essentially a taking position by plaintiff that there was sufficient evidence by which the jury could have found in our favor on residency. And the quote from Barth is, that's been repeated in other cases, you should remember that the solution to such a problem is always in the hands of the party and their counsel. Plaintiff below could have asked for an interrogatory to the jury, either to break out the questions or afterwards an interrogatory.
Counsel, on that issue, how would the interrogatory have read, the specific interrogatory? Would it read, was the plaintiff a citizen and resident of Florida who died from cigarette addiction?
Well, you could have two interrogatories. You could break the interrogatory down into two questions. The first would be, was Romeo Chacon a citizen of Florida when his lung cancer was diagnosed? And the rest of the question, or was Romeo Chacon? And then the second question, was Romeo Chacon a resident of Florida when his lung cancer?
So if either, for you to prevail in this hypothetical, would the jury have had to have checked no to both of those questions?
Under the trial court's rulings in our position, a no to one of those would have been sufficient. But so if you got a no to one of those, you would essentially be getting what the two-issue rule contemplates, an advisory opinion from the jury, so you know whether or not there was prejudice from the claimed error on appeal.
And the plaintiff would have had to preserve that issue. The plaintiff would have had to request for that specific interrogatory, or those two specific interrogatories.
Correct. And there's other ways to do that. You could also kept the main interrogatory and then afterwards say, haven't found that he's not a class member.
But to Judge Luck's point, if the trial court had done an interrogatory that had just said, was plaintiff a citizen and resident of Florida who died from diseases and medical conditions caused by their addiction to cigarettes that contain nicotine? Question mark. That would have been exactly from Engle. That language would have been exactly from Engle. that would have not done anything to help clarify the issue.
Well, correct. It will have put the exact definition to the jury.
So the jury would have answered, let's say, no to that question, then that would not have clarified the issue at all.
Correct. I don't think it would. Yeah, it's similarly if the same situation would be if the trial court had asked was decedent a member of the Anglo class. The Anglo class is calling all Florida citizens and residents. That would I don't know if that would have been an abuse of discretion, but it certainly would have been clarifying in terms of what we're canvassing in that definition.
Counsel, we've taken you way over.
Well, for those reasons, we'd ask that this court affirm the judgment.
Thank you very much. Counsel?
I'd like to address some of counsel's last arguments first about the two-issue rule. I don't know if the court, it is very subtle, but he started out by assuming that the trial court instructed the jury our way, that it was citizen or resident, and then they would be alternative means of proof, and then the two-issue rule would apply. But that's our whole point. The court didn't instruct the jury that way. It instructed the jury that citizen and residence are two elements, and that's why the two-issue rule does not apply under Guarente's. And counsel argued that we can't show which one of these the jury found against us upon. Well, that's not our burden. It's Philip Morris's burden to show that there's no reasonable possibility that the jury could have returned a verdict in our favor if it had been properly instructed. In other words, there's no reasonable possibility that the jury could have found Florida residence and no reasonable possibility they could have found Florida citizenship. And that's clearly not true here. We submit that the evidence of residency was overwhelming. But even if it wasn't overwhelming, it's just enough that we have enough to support a jury verdict under a residency or citizenship standard. And as far as needing to request an interrogatory verdict, I'd like to quote a little bit from that Guarente's decision, the one that spells out that two-issue rule doesn't apply to elements. It was actually quoting with approval from the fourth DCA decision review. And he said, "We do not believe the rule should be extended to require a claimant to demonstrate the precise element of the cause of action the jury found lacking." That's what counsel was just arguing. To do so would require the use of interrogatory type verdict in all cases detailing the elements of the claim and the defenses thereto. We do not believe this was contemplated by the Supreme Court in Scarborough. And so Guarente's, they quoted that with approval when they held two-issue rule doesn't apply to two elements, a denial of two elements. And in fact, the main case they're relying on, Bart also quoted a shorter section of that quote. There's a footnote in Bart where they're saying that the two-issue rule doesn't apply to a single cause of action. Well, in this case, class membership was treated similarly to a cause of action, spelled out with elements that had to be proven. On some of the other points that counsel made,
Quickly, counsel, you've gone way over. Quickly, go ahead and sum up what you want to.
there was a statement there was no mention of citizenship in Rearick, and that their argument in Rearick was based on legal residence. Well, the Rearick opinion actually says that the tobacco company's argument was that the smoker was not a class membership because she was not a Florida citizen or resident at the relevant time. That was actually the defendant's own argument in Rearick. And let me just quickly check to see if I have anything else extra critical. When the class was reduced from national size class to Florida, the purpose was not to ensure some maximal connection to Florida, the counsel argued. The purpose was simply to reduce the size of the class. And so there's no basis to read into that some intention to eliminate citizens of other states who are residents of Florida.
They even said it would be unmanageable.
Yes,
for the
that was
court
the only
system.
reason why. And just one quickly, in the court's first Engle decision, Engle 1, this court wrote that there's actually nothing wrong with a nationwide class. And I appreciate that, I'm over. Thank you.
Thank you.
We ask the court to reverse.
Thank you very much. We're going to take a quick 5-minute break. I'd like to thank both counsel on this case. Briefs were really good, very informative. Thank you very much for your time.
All right.